We don't use it anyway.
When the guy is going to bring me some water, can I have one of those cups? I don't have to swig it out. Yeah. Which I have done.
Is everyone here? We're ready. Yeah. Or
Just sit there swigging it because I didn't know if there was any
Okay, thank you. I didn't bring any water. Thank you so much.
Can I have a glass as well? I am quite happy to swig though. I mean, it's a bit unseemly.
I know that was my only concern. How appropriate it was swigging.
In the matter of the Dean of Begum and the Secretary of State for the Home Department.
Yes, yes.
May it please your Lordship, Your Ladyship. I appear with Mr. O'Kelly on behalf of the appellant who's sitting at the back of the court. Our learned friend Miss Smythe appears for the Secretary of State for the Home Department.
Yes.
I just wanted to confirm that with the court they had the relevant papers and bundles. They should have skeleton argument replacements from both sides, plus a short supplementary from the appellants. We seek permission to file that came in a week ago. And then the core bundle and the supplementary bundle.
Hold on. We have a revised skeleton argument from you. A skeleton, that's July. August from Ms. Smythe. I'm not sure I've got anything since then.
I've not
We don't
seen
have
it.
the supplementary dated for the case that was filed on the 22nd of November.
Just a moment.
I haven't seen it.
I know, I've seen all of them.
Right, now what was that dealing with?
My Lord, it simply addressed some of the factual assertions that have been made in the Secretary of State skeleton argument and made some short comments in response on deterrent effect and policy. I can speak to...
How long is it?
It's 5 pages. Sorry, I'll just check. 5 pages? It's 5 pages and it had an updated chronology attached to it. But in fact...
I'm sorry about this.
No.
Obviously something has got stuck somewhere. I mean, I think probably the simplest thing to do rather than we start handing around documents is for you simply to take us through the points and supply the document after.
My Lord, I will, and I've asked my learner junior to get a copy sent over. It was really to address those, as I say, those matters.
Well, if it's sent to my clerk, it can probably then be forwarded at least to me during the course of the day.
We have one copy.
Well, then my Lord can have that copy if he would like it, and I'll wait for it to arrive on screen.
Yes, right. And did you say there's an updated chronology as well?
Yes, it's attached.
I've not seen that.
I apologise for this. When we filed the replacement skeleton, which has got the bundle references, in that replacement skeleton there should be a reference to chronology with those updates.
Yes, I had that.
So, in fact, if we just work from that, that'll be adequate. We don't necessarily need to go back to what was the updated chronology attached to the supplementary skeleton. So, perhaps I can take it in the way. I'm glad I dealt with bundles. There's one authorities bundle, tabs 1 to 17, and I haven't discussed particular time. I probably should have done with my learned friend Miss Smythe, but I anticipate taking the morning until lunchtime, and then my learned friend responding.
Well, shall we see how we go?
Yes, well, indeed, of course.
I mean, it struck us. I'm bound to say that it might not be necessary for us to be hearing you for the whole day on this point, but we'll see how it goes.
I'm absolutely in the court's hands. Of course, it will, of course, depend on the way the court's response to the way we put our case. So I'm entirely content with that. But I'll aim to finish in any event before lunch. So in opening, we say that this case raises an important question on the interpretation of the Directive 2004-38, and the issue as the court is aware, is what's the effect of Article 3.2 of that directive, and whether it's limited in effect to cases of naturalised citizens. My Lord Justice Singh granted permission in this case specifically on the basis that there hadn't been a previous authority from this court, or indeed from the CJEU, and particularly to address the question of whether the tribunal, the long, quite historic decision of Moneke from 2000.
Can I interrupt you, and I apologise, to say that I have located in the bowels of the computer the document which did arrive, so far as I'm concerned. So I think we're all there and can follow you through the document.
That's the supplementary document.
22nd
yes,
of November.
I'm so grateful, my lord. So I was hopefully confident that it had been appropriate.
Well, not only that, but now having looked at it, I confess to having read it.
Well, that's even better, I think, for the purposes. But I appreciate that there's been a slight flurry of documents most recently. Thank you. So we were slightly confounded by the COVID safe provisions in relation to water. So that's the core issue, and it is important for this is a question for this court will have to interpret the directive, because there is no authority, and that I think is common. Both parties agree that position, and so the question is, what are the rights to reside of third country national family members for naturalised EU citizens, where their dependency in the country from which they came arose before that citizen was granted his naturalisation, but importantly, on our facts and for our case, continued thereafter without interruption. So there's been a number of cases about continuity, a number of cases about interruption, about lack of residence post migration, but none of those on our facts arise. So we've got quite what I would say is a neat and good set of facts to evaluate this proposition. So the single issue is whether the appellant is an other family member or extended family member on the basis of her dependency on an EU national. We say it must be done as there's a requirement for this to be a purposive construction, and that the CJU's decision in Rahman and the Advocate General's judgment will opinion will assist in the way the court must approach the question. I refer back to my Lord Justice Singh's grant of permission only to observe that not only is there no authority, and not only does was it identify that this court should consider Moneke, but also to observe, as we do, that Moneke itself, we say, contains no reasoning on the question in issue in this case. It does contain reasoning in relation to dependency, when dependency should arise, but it doesn't specifically deal with the question, or we say, because it wasn't relevant on the facts of that case, as to the question of dependency, the pre-existing question of dependency in the circumstance as here, where the person migrated to the UK, remained a dependent, and sought to rely on treaty rights in the way that this appellant has done. So we submit, as we did below, that the decision in Moneke's wrong is the sole authority on the point, and certainly we say that it is now also clearly contrary to the other line of authority that we also rely on in relation, which we refer to in Lassal, Ziolowski, in respect of accession states, and that provides that rights which arise under the Citizens Directive must apply to the present effects of situations arising previously, and we will come back to look at that. Well, I further say in opening that, importantly, any interpretation in relation to the Citizens Directive is about the rights that flow from the directive in relation to the promotion of integrity and family unity, and that the factual dependency is key in interpreting the provisions of Article 3.2, and as I indicated earlier, many of the authorities struggle to have any positive factual background in relation to any kind of continuity of dependence and dependence on the EU national, both pre and post migration. So that's...
You say that we have, with respect to your client, a good set of facts.
Yes. Or a useful set of facts.
A useful set of facts, but it is, in a sense, a good set of facts because it's quite a crisp situation. It doesn't often find. It would be the case that the current decision under appeal might be thought to be a hard case from your client's point of view. But one would also have to consider, wouldn't one, less hard cases where there had been a dependency for a very long time after, a dependency for a very long time, and there wasn't just 5 weeks, and so forth, but 5 years before nationality was.
I appreciate that. I'm less concerned with, in fact, that sort of timing. And indeed, Miss Malone, friend Miss Smythe, observes that this case isn't necessarily about fairness; it's about interpretation. But
no, I understand you weren't pushing the point, but it's obvious to us all, I think, that the interpretation of this has got to cover every permutation.
Yeah, indeed. And the primary issue that we rely on perhaps isn't specifically about the 5 weeks, although we do emphasise that because that is the case. But the factual context, importantly, is that there was a long-standing dependency from 2003 to 2010 prior to the migration of the appellant, and that she only moved, the evidence is, and I'll take the court to it, once she knew her uncle had had his Italian nationality authorised. There's a decree in January 2010, albeit that he hadn't done the citizenship ceremony, which he didn't do until May. So
there's no fact findings on that at all, are there?
The documentary evidence support that.
Yes, but there are no fact findings.
That is,
so how can you argue that in front of us if there are no fact findings in the tribunal to that effect?
Well, my lady, what we say is that those are the relevant facts in relation to.
Sorry, that's not the answer to my question. With the greatest respect, this court deals with fact findings that are made in the tribunal below.
Yes.
You can't come to this court and put documents before us and ask us to draw fact findings that have not been made by the tribunal.
Well, my lady, in the supplementary skeleton argument, we dealt with the point that the tribunal had made a finding at paragraph 15D that the appellant had already decided to move to the UK to study here with the advice and support of her uncle, and that he had already planned to move to the UK in due course. Yes. That is the fact finding that those are the facts that we have.
Yes, but there's nothing on the back of that to say that he'd already made an application for Italian nationality at that point, or that she knew it. And I'm afraid that, from my perspective at least, so it's not speaking for my lords, that is not a legitimate line of argument.
Well, my lady, I'll only refer to those facts as they appear in the first-tier tribunal decision, which we expressly dealt with in our supplementary point, the skeleton argument. And I'll take the court back to that. But it's.
I think I drew you into a discussion of the facts. But
perhaps I will come back to that. But I in a way, because we were emphasising the facts, perhaps I was happy to be drawn, or rather allowed myself to be drawn there. So.
But you have to win. Is this right? You have to win, irrespective of the facts, on the interpretation. It's a question of law that we have to decide.
We have to win precisely on the question of law, insofar as it affects, importantly, all persons who are similarly situated, i.e. those who acquire citizenship, and what the impact on their free movement rights would be, or it is and would be, in relation to pre-existing dependency.
Yeah, but to test that principle of law, is this right? Do we have to strip away whatever the particular facts of this case may be, what you've told us, which may or may not be right, and may or may not be something that this court can take into account on this appeal, about the fact that she knew that he'd already been granted his Italian citizenship, but they were waiting for the ceremony. All of that, at least to my mind, I think we have to strip away, because you're either right or you're wrong. on the interpretation of law.
My lord, I perhaps overemphasise that particular fact. The critical facts are, as we've seen, as it is agreed in this case, and the question of law to be applied to this context is what happens to the pre-existing dependence of persons who become EU nationals
Yes.
when evaluated in the circumstances here, where not only do they be the pre-existing dependency, but also the fact that they remain dependent when the person acquires their EU nationality, and remain dependent once the person has migrated to the UK in exercise of treaty rights. My learned friend Ms. Smythe's argument, as I understand it, is entirely forward-looking, and therefore can have no. Those historic facts have no relevance to the question of interpretation. And we say, in summary terms, that the question in community law, that dependency and giving effect to dependency when dealing with rights arising under the Citizens Directive is of critical importance, because otherwise there would be what we say is a chilling effect or a deterrent effect of persons who acquire citizenship to then only be entitled to bring their Regulation 7 dependents, wife, spouse and minor children, and not being able to bring persons who they had supported for a significant lengthy period of time and continue to do so. And we say that a proper examination of Rahman and SM, but particularly Rahman, both in relation to the Advocate General's opinion and the judgment, supports that analysis, because Rahman wasn't looking at the question of when the citizenship arose. It was specifically looking at the question of dependency and why the factual context of dependency was important in determining whether those persons had rights under the.
You have to be quite careful, because looking at taking up the point that you made, which is that apart from Moneke, there's no authority on this point. There's obviously the possibility, and I'm not thinking about any particular passages or any particular cases, that one uses decisions on allied aspects of the directive and the regulations and tries to read them across to something that they weren't really intended to apply to. So I'm speaking for myself, I'd be grateful if we went to the authorities and understood the points that you make on them, but with that degree of caution, I think.
Yes, indeed. And so what I was in summary going to say was that we say nothing supports the Secretary of State's analysis of how the construction of an extended family member. And the Secretary of State's position in summary is that this case has nothing to do with EU law. So we need to, there's obviously a very wide gap between us. And what we say is that the court should, that if we adopted that literal construction of a limited temporal scope, that's contrary to the context and purpose of Article 3.2, contrary to the obligations to facilitate and not deprive that article of useful effect or interfere with free movement rights, and that a proper construction of that should enable naturalised citizens to avail themselves of Article 3.2 at the point of nationality, at the point of acquisition of nationality, and that's what the fundamental status of citizenship of the Union.
Can the argument be boiled down in the way that you just touched upon, namely that if you're right, then EU law applies and should be applied purposively. If the Secretary of State is right, it doesn't apply at all.
I think that's the issue between us.
I mean, I'm not siding with anybody on that, but
the way my learned friend and I have both put our case is to say that this is, if we fall within we're either within the definition of other family member, and if we're in it, then there's nothing that my learned friend has, although the Secretary of State hasn't actually
other family member of an EU citizen.
Yes, indeed, of an EU citizen. But we haven't. There's nothing the Secretary of State has suggested that on an extensive examination of her personal circumstances.
No, but you understand the point that I'm making, so just for my purpose at least. In the end, are you accepting that if you don't fall within that category, then it's not a question of EU law?
yes, I think that's, sorry, Malona Junior just reminds me that the way we put it is that in order to determine that question, you have to interpret Article 3.2 purposively in order to determine the question. Perhaps
exactly. But in the sense that if having done all that,
yes,
you fall short, then the consequence is not just that that the argument falls short, as it were, but you drop off the directive altogether. And I think Mr. Kelly's happy with that.
Yes, that is correct. Yes, that is.
Right, I've understood.
So we say in order to evaluate the question, we have to look at the broader EU principles, the text of the directive and the preamble, the recitals, the regulation, the case law on dependency, the case law on present effects, and then the facts in order to reach the conclusion. So that's the way in which we propose to do it. Just coming back to the principles, therefore, the first point that we make is that, as Mr. Justice Blake has recognised when deciding Moneke then, he said, well, this is my position as I see it now, bearing in mind that there isn't any higher authority. So he that was an interpretation by the upper tribunal, but without, what perhaps he said, I think it's for the moment, or as matters presently stand, was I think the way he described it in his judgment. Since then, there have been two key rulings of the Court of Justice. The first is Rahman, and the second is SM Algeria, which I'll come to in a moment. They both define the scope of Article 3.2, and importantly identified that member states must confer a certain advantage on applications that were submitted by third country nationals compared with other third country nationals. That's perhaps for the court's note, and I'm going to take the court to those two authorities just in a moment, but just to say for the court's note, it's paragraph 21 of Rahman and 60 of SM. And then, of course, then if one were within the OFM definition, then an decision would be founded on an extensive examination of the factors unjustified by reference.
But all this is common ground.
But, my lady, it's important because we're asking the court to adopt a purposive construction. I think those principles that we say are important in how that is arrived at.
What is established in the authorities, including Rahman, is that the purpose of the directive is to facilitate free movement of EEA nationals within the EEA, and that dependency or family circumstances may have a bearing on the facilitation of that, but family reunification is not the primary objective of the directive.
We accept that it's not the primary directive, but that the directive mustn't be interpreted in a restrictive way. That is a principle that is also found in METOC and as referred to in Rahman, that to facilitate the facilitation of the exercise of the fundamental right to move and reside freely, which is conferred directly on citizens of the Union, and that one of the objectives of the directive is to strengthen that right.
Yes.
So we say that when interpreting 3.2, there has to be an emphasis on facilitation. And importantly, when we come to look at the recitals, one of the purposes of 3.2 is to maintain the unity of the family in a broader sense. So that's why it's not confined to the Article 8 ECHR type definitions. It is about those who are defined to be dependents.
But only to the extent that it has a bearing on freedom of movement of the Union citizens, so it becomes rather a circular argument.
The importance is not that when in looking at Article 3.2, one of the purposes that are identified by Rahman and by SM is that the scope of that article identified by the Grand Chamber is for those who maintain being an important word here, close and stable family ties with an EU citizen.
Yeah, with an EU citizen being the absolutely operative words. So if you look at Article 3.2a and the language of it, which is really what we need to concentrate on, surely. Family members have to be somebody who, in the country from which they have come, that's Bangladesh, are dependents So at the time that they're in the country from which they have come, are dependents or members of the household of the union citizen having the primary right of residence. Now, surely the natural interpretation of that is that at the time when somebody is in Bangladesh and is a dependent, they are dependent on or a member of a household of someone who is already a union citizen with a primary right of residence. And that makes complete sense, because that person's freedom of movement can then be impacted by the ability or otherwise of his or her dependents to come to the part of the EEA that he wishes to move to.
Well, my lady, we know from the case law, which I'm going to come to perhaps in detail, 4 cases, but from the Aladiselu case, we know from that case, for example, that the dependents don't have to be residing in the same country, and we know that they can come before the citizen, the union citizen themselves.
Absolutely,
migrate.
but nothing in either of those cases, in Aladiselu or in any of the other cases, suggests that the EU citizen doesn't have to be an EU citizen at the time when they are dependents outside of the EU. In fact, in Aladiselu, the Dutch national was an EU citizen at all material times.
I accept that, my lady, and the point that we make in relation to construction, perhaps I will come back to looking at those recitals in a moment, is that the temporal, the words in Article 3.2 are dependents. Means that we say this must mean were dependents and still are, because it allows people who have already moved, for example, in the Aladiselu context, to apply under this article. So it can't mean those who were dependents and no longer are, and it can't mean those who were not dependents in the country of origin but now are. But it can't. We say that's critically important. And when we're looking at Rahman, say for example, who didn't have any current dependency and never had any prior dependency on an EU citizen, that's why the court reached the conclusions it did in that case, because there was no prior dependency on an EU citizen and there was no subsequent dependency post-migration on an EU citizen or membership of their household.
The continuing dependence is something that comes later. That's a matter of domestic law.
Yes.
But our dependence means at the time when they're in the third country, which means prior to their entry into the UK. So who in the country from which they have come are dependents, fair enough, they've got to be dependent in the sense that we all understand, all members of the household, of the union citizen having the primary right of residence. It would help me to know on what basis you say that can be read as meaning a person who is not yet a union citizen having a primary right of residence, but who may become one in 5 years' time.
Yes. So if I go back to look at perhaps it's useful now to just turn to the directive, which is at tab 2. Excuse me. And look at the definitions. Of that, sorry. Mine is numbered at 27 in the top right. That a union citizen means any person, this is under Article 2, the definitions, having the nationality of a member state. Not having it at.
Can I just interrupt you there? And I'm sorry to interrupt you, but I think one of the points that you make in your skeleton argument is that at the time when the application for a residence card was made, the uncle was a union citizen within that definition.
Yes, we say.
So I think is this right? One of the arguments you make is that when one is construing Article 3.2, the reference to the union citizen is simply identifying who are we talking about.
Who the person is. And the further support for that proposition is in the regulations itself, where we say at Regulation 8. I'll come back to.
Sorry, don't let me take you out of turn.
I'll come
all,
back to
please.
yes, to
Can you-
Regulation
do
8.
you want to take us through the directive?
So I'll start. That's right. Where I was planning to start with the directive, and if I may, just start with the recital, which is tab 218, and so which we refer to in our skeleton argument at paragraph 31. But just looking at the recital itself, this citizenship of the Union. This is under recital 3, should be the fundamental status of nationals of the member state when they exercise their right of free movement, and that in order to maintain the looking at recital 6.
Sorry, I'm just pausing on 3.
Yes.
I'm trying to grasp some meaning out of it.
I think the meaning of the recital, my lord, in my submission is that when they exercise their free movement, that the focus is on their status at the time they exercise their.
So citizens should be able to move around,
Yes.
and we're going to call that union citizenship
Yes.
as being the label or the status which allows them to move around. All right.
Yes, perhaps
So
there's nothing hugely illuminating about that. Then at recital 5, the right of all citizens to move and reside freely within the member state should, if it's to be exercised under conditions of freedom and dignity, be also granted to their family members, irrespective of nationality. For the purpose of the directive, the definition of family members, and then it's defined there, should include registered partners and so on. And then, critically for our purpose, recital 6, in order to maintain the unity of the family in a broader sense, and without prejudice to the prohibition of discrimination on grounds of nationality, the situation of persons who are not included in the definition of family members under this directive, and who do not enjoy an automatic right of residence in the host member state, should be examined by the host member state on the basis of its own national legislation, in order to decide whether entry and residence could be granted to such persons, taking into account their relationship with the union citizen and or any other circumstances, such as financial physical dependence. So that's the framing of the intention of the directive.
Sorry to interrupt you again. Do you submit that in recital 6 there's no temporal element?
We submit that a purposive construction of the recital does not.
Sorry, even on a literal. Is there any temporal element?
There isn't on the face of that recital a temporal.
Yeah, so you say that sets out one of the purposes of the directive, and that the phrase "the union citizen" is being used simply
to define the relation.
To identify who is the person we're talking about.
That's correct, my lord. And I say there's support for that in Article 8, in Regulation 8.6, but we'll come back to that. So that's what we say. Importantly, is what the directive is seeking to do, and then we come to the directive itself at page 27, top right. The conditions governing the exercise of free movement, which is what the subject of it is, and the limits, the right of residence under B for union citizens and their family members, and the limits placed on the grounds of public policy, public health and security, public health. Sorry, and then the definition: a union citizen is a person having the nationality. So you can't apply for under this directive unless the union citizen at the time of the application has the nationality. But it doesn't say and had it at the material time in terms of, there isn't a temporal qualification, we say there. Then 2.2 over the page, what defines what a family member with an automatic right of residence is, spouse, partner, and then the direct relatives in the ascending line and descendants, the direct descendants. And then Article 3, my lady referred to a moment ago, this deals with the question of beneficiaries. It shall apply to all Union citizens who move or reside in a member state other than that of which they are a national, and to their family members defined at the point of Article 2, who accompany or join them. And then, I know the court has looked at this, but just to come back to looking at the very particular text, without prejudice to any free movement and residence the person concerned may have in their own right, the host member state shall, in accordance with national legislation, facilitate, and we place an emphasis on the word facilitate, entry and residence for the following persons. Any other family members not falling under the definition, who in the country they have come are dependents or members of the household of the Union citizen, having the primary right of residence. And what we say back in response to that is that because one can make an application before the person as a dependent, importantly, if you're applying as a householder, it's more likely, of course, that the person will be living in the household of the EU citizen. But as the persons who are dependent don't have to be living in the same country in order for that dependency to be established, that what we say here is that if they are dependents, doesn't require them to be living in the same country, and that therefore it means to give this the purposive construction, which is to allow those who acquire nationality to bring their dependents, to have their dependents live with them in the country where they're exercising treaty rights, that therefore it has to be interpreted on the basis that it includes those who were dependents as well as those who now are dependents and continue to be.
The effect would be that you can bring your dependents in before you acquire nationality yourself.
My Lord, I don't think that is, in my submission, the effect of that.
So what?
Because that is the context in which Aladaselu was decided for somebody who was already an EU national.
Yes,
but we're not suggesting that the applicant, the dependent here, could move to the UK as the dependent of an EU national if they were before he was exercising treaty rights. That's not what we say.
But that's exactly what's happened here.
Well,
she's moved here as a dependent of somebody who was not an EU national before he was exercising treaty rights. He then exercises his treaty rights afterwards. And that's exactly the problem that you've got.
But the critical point in this case is that she is a dependent. She's at all material times is a dependent.
But she's not a dependent of an EU citizen.
She's not a dependent of an EU citizen until he becomes an EU citizen.
At the time that she comes.
We say that it would adopting the purpose of keeping this family, and the purpose of identified in the recitals and in the directive, which is to facilitate entry and residence, and to have regard to, importantly, the principle of maintaining the unity of the family where there are close and stable family relationships, which is why we say the facts in that context are important. Can't be properly construed as only including future relations.
I understand that, but I'm just trying to work out what the consequences of your submission are. Somebody arrives here as the dependent of a non-EU national.
If somebody arrives here as a dependent of a non-EU national, they'd have to be here lawfully, because otherwise they have no right. They have no rights at all.
They're not lawful. And then the person becomes an EU national. And what happens then? They become lawful?
Well, my Lord, in the cases, say for example of Metok and Gia, the cases.
I'm not interested in authority.
Sorry, yes.
Because we've established there isn't any.
Yes. In the context of persons who were here under, as say for example, spouses who were here under.
No. I'm talking about a dependent, which we've got. Keep it simple. That you've got somebody who comes in as a dependent of somebody who is a non-EU national,
Yes.
what is their status until such time as the person becomes an EU national?
They don't have any status.
No.
Yes.
So the consequences of your argument are that somebody who is dependent on a non-EU national can come into this country without any immigration status, but acquire it as soon as their sponsor becomes an EU national. That must be the consequence of the argument.
Well, there's a further consequence as well, which is that they can very properly be stopped from coming. If they're not entitled to come in, however much one might feel for the individual case, they've no right to come in.
My lord, they've no right to come in under EU law. That we accept. So for a person, and most persons in this situation would perhaps be in their country of origin, but for persons who are in the UK lawfully, as the applicant was,
Yes.
whose circumstances in law change as a result of her sponsor becoming an EU national and exercising treaty rights in the UK, and at that time she then, in
I
light
understand
of
that, but
that,
she happened to be here, and let's assume for the moment, I'm not saying
yes,
one way or the other lawfully, but your argument has got to work for somebody who turns up for the first time.
but for somebody who turns up at the first time, who's in the UK, if those circumstances prevailed, that their sponsor then became an EU national.
No, I'm talking about arrival at the gate.
Arrival at the port.
Yes.
Let's suppose that my lord's postulating the position where you have exactly the same situation as arises here, except that unlike Sabina Begum, the young lady who is dependent on the uncle and has been continuously dependent on the uncle, it continues to be dependent on the uncle but has no other lawful basis to be in the UK. Yeah. They turn up at the port. They can't then say, well, I'm exercising my rights to seek a family dependency residence card because my uncle's going to become an EU national in 3 weeks' time.
I totally accept that, and that if that person who was presenting at port in those circumstances wouldn't have any rights. So
then why? Because why that person, that seems to me to be the critical point that we need to focus on, is why that person wouldn't have rights, but somebody in your client's position would. Because one needs to look at the time. There has to be a time at which the application has to be evaluated. And at the moment, it seems to me that there are two rival points in time. One is the time of the application itself, and one is the time of entry into the UK. Now, Rahman says you don't look at the, or not Rahman, one of the later cases says you don't look at the time of the application itself because that would be unfair to people in the position who come here first with the relative coming later. So at the moment, may well be that you have a different submission to make about it. It looks as if it's at the time of entry. If it's at the time of entry, and the person concerned is not an EU national at that stage, then I'm struggling to understand how they could apply for a residence card.
we don't submit that it's at the time of entry. We submit that the rights, and we only have in this case that relied on the fact that at the time the applicant made her application to be considered for as an other family member, which was in 2015, and we'll come on to the arguments about whether it should have been 2015 or 2019. But at the time she made the application, she had migrated to the UK lawfully, was exercising her rights of appeal in respect of that status, and had continuing leave to remain until the conclusion of that appeal. I think my learned friend and I think we now probably agree on that chronology, whereas there's a suggestion that the appellant had been in the UK unlawfully since 2013, but she was here until 2014, and at that point in time she was then living with in 2014, when her leave to remain came to an end, she was living with her sponsor, who was an EU national in the UK exercising treaty rights, and she was his dependent and a member of his household, and and that was a continuing situation in relation to dependency than that which had previously been established. So we don't have to posit the argument that anyone can turn up at court and wait for their circumstances to catch up with the law.
Well, why not? If the key date is the date of the application, why does that answer the question about turning up at the port?
We say, because we're dealing with other we say if we're correct in relation to the definition of other family members, which isn't limited in time, and that allows a person then to be the determination of whether they are another family member because of that historic dependency and continuing dependency, then to defeat my lady's observations as to what to do with those people who never had any rights here and they just arose around them, that could arguably justify refusal on public policy grounds when one looks at the extensive examination.
Or it could mean that the construction for which you contend can't possibly be right.
Well, my lady, the way we respond to that is in two ways. The first is that there shouldn't be a restrictive construction, and particularly where if on the purposive construction, which includes the persons in the appellant situation, if there's a way to defeat the public policy objection, which is, well, after an extensive examination of your circumstances, we decide that you're not entitled because you were in the UK unlawfully for X number of years.
Could you just help me? What's the analysis if, for example, your client had gone to Bangladesh and made her application from there as a dependent? What's the analysis then?
If she had gone back to if she went back to Bangladesh
with continuing dependency,
yes, she would be entitled to a residence card.
Yes.
So it isn't that she doesn't have a remedy in some senses. If she'd remained in Bangladesh, or if she went back to Bangladesh now and returned, or if she went to if her uncle went to another European country, they could then apply for a residence card there as another family member. So we say the fact that she could just go back to Bangladesh and make the application from there demonstrates why the construction is in our favour, because the remedy, if we're right on the construction point, which is that she comes within the definition of other family member, the objections can be in relation to my lady and indeed my lord, in relation to what to do with persons who have been, for want of a better phrase, hanging around without leave or any status for a number of years. That can be dealt with within the application process by saying, no, I've done an extensive examination of your circumstances and discretion. On the basis of the discretion that the host state has, I'm going to refuse you. The Secretary of State acknowledges, and I think we're all, in answer to my Lord's first question, we know that situation hasn't occurred here yet because the Secretary of State hasn't done that extensive examination and considered the exercise of her discretion, albeit that the tribunal has made rather relevant findings of fact as invited by Mr. Justice Blake, and the approach of Mr. Justice Blake in Moneke, he invites tribunal judges to do that so that the courts and the Secretary of State have got a familiar and an important set of facts found. But that's what we say is the way to defeat the public policy argument. So it does support our analysis that that if we're right on the construction point, it doesn't mean that a person can turn up at the port and say, I'm entitled to enter. It means that a person who makes an application at a time when they are a qualifying person, a qualifying family member, can have their application considered, and then the Secretary of State can move on to examining whether or not there's a reason to refuse to exercise discretion, and that's a perfectly workable and quite, in my submission, perfectly workable.
That may be right, but forgive me for going back to the text of paragraph A of Article 32A. Does your submission give any effect to the clause in the country from which they have come?
We say it does, because it's still defined. Importantly, we accept that there needs to be a dependency on the person in the country from which they have come. It's not simply persons who become dependents whilst after they've left the country from which they have come. It is dependents in the country from which they have come, dependents on the person, on the EEA relative, on the EEA national. And just in answer to my lady's question, that a person cannot apply, and my lord's question before, for a residence card based on EU citizenship at the time of arrival if the sponsor doesn't have EU citizenship, because they just don't qualify. That's the end of the end of the matter. We're only seeking to say at the time of the application. So if a person turned up at port in the applicant's situation before the uncle had become an EU national, she wouldn't qualify. She doesn't. She's not the dependent of a family member of an EU national.
Well, it seems to me a bit odd that one's status is defined around the question of which side of the border one happens to be at the time.
My lord, well, we went. There's two observations. One is she could go back and apply from Bangladesh as she had on the facts, because she's a continuing dependent. But that is not the purpose. That is not a purposive construction in the context of EU law. And I've given the court a clear way through dealing with persons who would.
Well, you say they all qualify, but as a matter of discretion, when it comes to the second stage of the analysis, they would fall to be refused on public policy grounds.
Only for persons whose family member is already an EU national.
As I understand it, your point is that the person concerned has got to be an EU national at the date of the application, at the date of the application itself, and not at some other date. And so the acid test is what is the status of the sponsor as at the date of the application, not at the date of entry into the UK. And one of the problems with that is that Aladazilou says that the date of the application is not the appropriate date at which you judge these things, because if it had been at the date of application that one actually looked to see whether they were qualifying, they wouldn't have qualified.
But it's important.
For other reasons.
In Aladazilou was considering the question of whether there was an adverse effect on the EU citizens' free movement rights by not allowing dependents who had come to the UK already.
Yes.
Who were dependent on that EU national. So
that was Article 3.1.
That was a 3.2 case.
No, it was 3.2, and what the Secretary of State's argument in that case depended on various observations that were made by the Grand Chamber in Rahman, which were focusing on the date of application, or appeared to be focusing on the date of application for entry, because Rahman was a case where the applicants were coming from a third country into the EU and the national was already here.
Yes.
So that's your sort of common or garden situation where you're applying from outside to join. And the Secretary of State in Aladazilou was saying, well, if you apply what was said in Rahman literally to the three applicants who got there first, they wouldn't qualify, which was true. And so the Court of Appeal said, no, in order to give effect to the intention not to inhibit free movement of the EU citizen, it shouldn't matter who got here first. And therefore you move away from the date of the application.
Well, lady, both Rahman and Aladazilou were dealing with, and I'll come to those cases just on the facts very briefly in a moment, but they're both dealing with different questions. Which, in relation to persons who were already EU nationals and have these two different sets of Article 3.2 claim dependence. In Aladazilou, it was accepted that they were dependents in terms of these remittances and so on, and the only question was whether they were entitled to the issue of title to be treated under Article 3.2, and the court's analysis there was not even a chilling effect, the possibility of an adverse effect on the facts of the case was the way it was expressed in the judgment. The possibility of an adverse effect was the reason that the court gave for that construction. In Rahman, again, what we say is that the court was looking at a different question, which was concerned with the family members of not of the EU national, but of the spouse of the EU national. And importantly, in Rahman, I think it's important just to remind ourselves of the facts of Rahman, which are that there was no finding of dependency. So they weren't part of the EU national's household previously. They didn't continue to be dependents, and nor were they part of the household in the UK. So there was no factual nexus.
But none of the factual background in Rahman mattered because these were questions of interpretation of the treaty for the CJEU.
Yes, the court was interpreting the question of not of the question of dependency and when it arose, not dependency on the. They weren't dealing with the question.
Well, I agree with that. I mean, we're all agreed that there is no decision that's directly in point apart from Moneke, which is opiter and not reason.
Yes.
But what I'm trying to drill down to, probably without a great deal of success, because I'm not expressing it as clearly as I might, is that when you're looking at Article 3.2 or the equivalent in the regulations, there has to be a point in time at which there is an evaluation of whether somebody qualifies or not.
Yes.
I think we can agree on that. It can't be two different points in time. It's got to be one point in time. And the rivals seem to me to be the time at which they come into the UK or the time of the application. Now, you have understandably nailed your colours to the mast of the date of the application.
Yes.
But I'm struggling to see how that fits with the language of 3.2, who in the country from which they have come are dependents, because that's looking back to the time when they come into the UK.
You know, my lady, in order to give this the construction, this article needs to be construed for persons who acquire EU citizenship, and that apart from the passages in the recitals, which is about the promotion of family unity and stability. If it was in the consequence of making it entirely forward-looking from the date of acquisition, and therefore it could only be where a dependency then arose, would not be consistent with the principle of promoting family unity where there are close and stable ties. That is that's the point that we make.
So on your interpretation, how should the word "are" be construed?
We say that it should be that they were dependents,
So "are"
and
means
still are, because as I say, it can't mean those who were dependents and no longer are.
But the "and still are" comes later. The "and still are" comes under domestic legislation, and that is very well settled. So you can't get "are" meaning "and still are," because that is a matter for the national legislation, the question of continuity, and that has been that's been very clearly said in Ober, amongst other things, in Chowdhury.
Yes, I accept the continuing requirement for dependency is in the regulation.
Were and are.
Sorry.
Yes.
Is that what you're arguing for? Is were
and
are?
still
So
are.
insert were and.
Were and still are. Oh, and are. Yes.
Yeah. And in support of that, one of the submissions you make is that if this has the construction which the Secretary of State gives it, what possible sense?
Did it exclude?
Sorry, can I just finish?
Oh, so sorry.
What possible sense would that serve? Because a well-advised applicant would just make sure that she goes back to Bangladesh and makes her application there.
Yes. my lord. And
So what you're asking is, what is the point of all of this? What are you trying to achieve in practice and in a sensible way? And if it can be defeated, if the Secretary of State's construction can be defeated simply by putting somebody onto a plane back to Bangladesh, what on earth is being achieved? Whereas on your submission, you say something very real is being achieved, which is the purpose of maintaining family unity, which is one of the objectives of the directive.
My lord, indeed, but that is what we say. And I think I've said it before. I won't say it again. But we can defeat the broader objections through the discretion route. Just to answer my lady's observations about Obo and Chowdhury, those were both cases where the dependency was not accepted for different reasons. So in Chowdhury, for example, there was no continuity of dependency. So
4-year break.
That's why those cases fell to be excluded. That's why I say
yes, but that wasn't the reason I was drawing them to your attention. It was for the principle that the question of continuity is governed by domestic law rather than EU law.
The principle of continuity is what I'm asking the court to read in to give this article a purposive construction for the purposes of people who have acquired citizenship. And the fact that it appears in the domestic regulation is only supportive in some way of that proposition, because that's...
Well, no, because the CJEU in Rahman said that is something for the domestic court to consider. It's not part of the EU law. You're saying that we should imply it into the EU part of the regulation, and the Grand Chamber has said it's not part of the EU regulation.
Well, I accept it's not part of the
directive.
Of the directive, yes, but in order to give it a purposive construction for this context, which obviously wasn't considered in Rahman, in my submission, it is supportive of the proposition, or perhaps it's prayed in aid, that for the purposes of persons who acquire citizenship and have pre-existing dependence of long-standing or short-standing, they need to be dependent, pre-existing, and then and still be dependent. Because otherwise, those who acquire citizenship would have no meaningful remedy in terms of maintaining the unity of their family who are in the UK.
So one has to.
Yes, I think shall we move at some point to the regulations? Because I think I sense you've been trying to get there.
Yes, I'm great.
And just to pick up any points that
yes, I wonder if
arise there.
just wanted to respond to my lady if there was.
Yeah, well, I just wanted to make sure I had a proper, accurate note of your submission. So, in order to give a purposive construction to Article 3.2, it is necessary to read the word "are" as meaning "were" and "are," with an element of continuity to the dependencies. Is that an accurate?
It's necessary for "were" and "are." The continuity "are" is a temporal, as in now at the time of application. I don't have to go as far as continuity, but "were" and "are" is the way that we describe it.
Right.
The authority for the proposition. Sorry, the way in which we ask it to be construed. And we expressly say it doesn't mean those who were not dependents, but are in the country of origin, but are in the UK and now are dependents. That we're not making that observation or suggestion, because this is to give effect to the close and stable family ties that already exist for a person who becomes an EU national. And there isn't any other way to do it, we say.
You've got that point.
So, Regulation 8, the regulations are at tab 1. So, Regulation 7 defines family members. That's the top numbers, page 7, top right. And Regulation 8 is on page 8. So the 8.2, the conditions in the paragraph are, the condition in this paragraph, is that the person is a relative of an EEA national, which we say she is, and residing in a country other than the UK, and is dependent upon the EEA national, or is a member of the EEA national's household, and then either, and I'll come on to that in a moment. We say defining the dependent upon an EEA national is defining the person, the relationship, back to the point I made to my Lord, observation to my Lord Justice Singh in relation to the recital, the way in which the recitals are expressed. And just if we just move to the top of page 9 just for a moment, in these regulations, the relevant EEA national means extended family member are referred to in paragraphs 2, 3 or 4, the EEA national to whom the extended family member is related. So the definition, I appreciate it refers to the EEA national. Of course, it has to refer to an EEA national because you have to have an EEA national sponsor at the time you make the application. But the important, we say, construction in relation to dependency is about the person to whom they are related. And that's 8.6.
So I'm not following this. In 8.2b.
8.2b.
Yeah, it is residing.
Is residing in a country
in a country other than the UK. I mean, your client cannot possibly be said to be residing in a country other than the UK.
Yes, I accept that. In order to read, perhaps I'll come to the 8.6 point in a moment. But if you read on,
It's 8.2b2, isn't it? Has joined.
Has joined.
They can't have joined him in the United Kingdom if they're still residing somewhere else.
Yes.
So you've got to read it.
You have to read it in a back to purposive way. The drafting is somewhat difficult, and either is accompanying or wants to join in Little Roman 1 or Little Roman 2, or has joined and continues to be dependent. And this court has interpreted join, and the Secretary of State, I think, has accepted.
You can join in two directions.
Yes. So that's the wording that we have there.
So is this another is or was?
Yes. We say that is dependent on the person defined as the EEA national, i.e. how they're related. That comes up in 8.6.
But so the is or was
Yes.
is at the end of the first line of sub 2, isn't it?
Yes.
It would govern everything that follows.
That would allow.
So the insertion that you say purpose of construction would in effect achieve would be the condition is in this paragraph is that the person is or was.
As long as we then accept that the definition of EEA national there is the person.
Isn't it is and was rather than is or was?
Is and was.
Is and was.
And was. Yes.
Sorry, it was an and in the directive as well.
Yes.
Is and was.
Is and was. And that way, defining the EEA national as the person who acquires the nationality, because it's the relative of an EEA national.
Sorry, can we just take this a little bit more slowly?
I'm so sorry.
No, it's not your fault at all. This may matter.
Yes.
Has joined the EEA national in the UK. Now you say, as I understand it, the phrase the EEA national there is not some kind of temporal requirement.
Yes.
It is simply to identify the person we are talking about.
Yes.
Because then you go to the definition of the relevant EEA national means, in relation to an extended family member, the EEA national to whom the extended family member is related.
Yes.
So in other words, would this be right? Could you, in a sense, put square brackets around the phrase the EEA national and simply put the uncle's name? Has joined Mr. X in the UK.
Yes. And the reason, the primary condition, if I can just repeat, is that at 2A, you are the relative of an EEA national. So in order for anything to work, the uncle has to be an EEA national, the sponsor. But all the others are dependent on the EEA national.
Yeah. I know this may seem very obvious to you, but this may be fundamental to what this appeal is about. So can I just be absolutely clear? what your submission is.
Yes.
Are you saying that when it uses phrases like has joined the EEA national,
Yes.
that's not implying that there is some kind of temporal requirement that at the moment when they join them, they were an EEA national? It's simply identifying who are we talking about. It's Mr. X.
That's correct.
And so does your client fall within the definition? Is she a relative of an EEA national? Yes, she is, you say.
Yes.
Because that's when she's
So she's
applying.
yes, that's an EEA national.
You say, was she residing in a country other than the UK? Yes, it must mean was, because otherwise the later phrase has joined doesn't make any sense.
Yes.
And has she joined the EEA national in the sense of has joined Mr. X
Yes.
in the UK and continues to be dependent upon him?
Yes.
I'm not saying that you're right.
No,
Let's
but
not
that is the
understand
logic.
that's how you can that you're saying this is all a set of associations, relationships between two persons.
Yes.
That the phrase EEA national, use of it, rightly or wrongly, is not also importing a temporal requirement
That's correct.
that at the moment when she moved into the UK, he was an EEA national.
Yes.
Is that right?
Yes, and it does, and we say that it doesn't import a temporal requirement because to do so, when one looks at the impact, would it have a restrictive interpretation for persons who require EU nationality and are in exercise of treaty rights. It may be a very small point, but I do emphasise it in 2A, which is the qualifying condition is that you're the relative of an EEA national. That's the qualifying condition. The other references are all to the EEA national. And in the Regulation 8.6, the definition is the EEA national to whom the extended family member is related. So,
well, the Regulation 8.6 definition is in relation to a phrase that doesn't actually appear, which is relevant EEA national.
yes, well,
The words relevant EEA national I have yet to find in this particular section of the regulation.
yes, it may be that, yes, I think
We
the
can all agree it's
italicised relevant.
not best part of not best
Yes, the quotation
draftsmanship.
marks perhaps should go before EEA national.
Yes,
Yes,
rather than relevant.
I agree.
Yes, that's the way I would. But
Could you just help me as to the context of this? Because other members of the court maybe, no doubt, are much more familiar with the regulations as a whole. But we're here in the foothills of this regulation with definitional sections, trying to get as much sustenance from the definitions as we can.
yes,
Could we just step back and you could educate me briefly about what the Secretary of State is doing under these regulations? What is the process? That may help us to understand when the whole thing, as it were, crystallises.
yes.
Is this in Part 2 under EEA rights? I'm not sure whether we have it in our bundle, but I was trying to catch up with it in the regulation as a whole.
This is a person. Sorry, if I understand my Lord's question correctly, that a person would be applying for a residence card with reference to I am either a family member under Regulation 7.
Yes. So, what does the regulation contemplate in relation to that application?
It contemplates.
Whereas your client's application, as it were, situated
yes,
within the framework of the
It
regulation.
contemplates that there is an application form and one has to assert the evidence of identity and relationship. Those are the key.
Yes. So what section of this, what regulation of this is the application being made under?
The application was being made
Regulation
under
18.
Regulation 8.
What's she asking for?
It's asking for a residence card under
Yeah.
Regulation 18.
18. Thank you. Do we have 18?
And interestingly, I've now found the phrase relevant EEA national,
Relevant EEA.
which is in Regulation 18, Subreg 4, little b. And that's where the phrase appears. Relevant EEA national.
So just
Yes, it's a qualified person.
taking it steadily.
Yes.
your client is making an application under Regulation 18.
For the issue of a residence card.
Yes.
Right. So could you? I'm sorry if it's. Is it in the bundle? What page?
Yes, it is.
15.
Yeah, page 15.
Thank you very much. All right. Well, would you mind, Miss Ike, just walking us through what is happening here in this case with reference to Regulation 18?
I'm so sorry, I'll just find it.
It's at page 15 of the bundle.
Yes, I see, sorry.
So I've got there now.
Yes, thank you. So the issue, the Secretary of State must issue a residence card to a person who's not an EEA national and is the family member of a qualified person or of an EEA national with a permanent right of residence.
Right. So that's the must under 1, and we're under 4, are we?
And then on production, and then what has to, in order to make an application valid, that needs to have a valid passport and proof that the applicant is such a family member. So that's the sort of qualifying requirement.
Yeah, we're not talking about family members. We're talking about extended family
Yes,
members.
sorry.
So it's paragraph
Yes.
4.
So we come back to the Secretary of State may issue a residence card to an extended family member if you don't fall within.
So
the
here is a
third-
discretion, not a duty.
Mm-hmm.
Yep.
Yes.
And then we
if-
see what the qualifications
Yes.
are.
And the qualification is the application must be accompanied or joined by a valid passport, and the relevant EEA national is a qualified person or an EEA national with a permanent right of residence under the regulations.
Yep.
So, and in all the circumstances, it appears the Secretary of State appropriate to issue the residence card.
Yeah. But is this right, that you're not going to be able to get through the gateway of paragraph 4 unless you fall within the definition of an extended family member?
That's
Which
right.
is why you have focused on Regulation 8,
Yes.
on the meaning of that phrase.
And that's why we say the Secretary of State is put her case on the basis that you're not another family member, which is why you don't get to the examination of the discretion or the extensive examination as to whether or not it appears the Secretary of State appropriate to issue the card. And I say that discretion, we say that we do get through the gate if you interpret the regulation the way which we contend for. And that discretion is the way in which the court can be satisfied, and the Secretary of State and anyone else concerned about it, that there's no obligation to issue residence cards to people who, on an examination of their circumstances, either are no longer dependent or have been in the UK unlawfully or and so on and so forth. And that's why that provision exists. And that's, we say, the answer to what is effectively a public policy argument put forward by the Secretary of State. She's trying to contend for the argument that this is simply a construction point and it's nothing to do with EU law. And we say, no, it's everything to do with EU law and how to give effect to those close and stable family ties which exist for somebody who requires citizenship of the EU. And if you don't construe it in the way for which we contend, then although the applicant or the applicant has a remedy, which is to go back to Bangladesh and apply for a residence card, that cannot properly be a purposive construction of the regulations. And say back to the point which is if we are, and if the court does adopt the relevant construction, but the Secretary of State decided there were reasons in other cases, not necessarily in the facts of this case, but in general terms addressing my Lord's point about how does it apply in all cases, then the Secretary of State has that discretion in any event. So there's no public policy.
I now understand, thank you, how the definition section,
Yeah.
the definition Regulation 8 fits within the structure of the regulations. But the regulations obviously contemplate as the paradigm case, but you would say not the only case, that the person is not in the UK, is residing
Many cases may
in
be
another country.
in that scenario, but that is not, of course, the reason that we are here to look at the question of what to do in these particular circumstances. And the two circumstances are, one, which is about what happens when a person acquires citizenship, which isn't necessarily clearly, unless you adopt the construction I posit or contend for, covered by the regulations, and secondly, what to do with the person. And we say consistent with general principles of community law, which is that if a person is here and that can be regularised, say for example in relation to spouses, that's how the Court of Justice.
Is there any significance to be attached to the fact that nothing is said in the directive or the regulation about people in your client's situation? In other words, one might have expected them to say, well, if you get citizenship later, well then that reads back.
In my submission, that was in my submission there is no significance, because the whole purpose of the directive was to construct rights for persons to be able to have a constructive interpretation of a person who acquires union citizenship. There was obviously an encouragement for persons to acquire union citizenship, and those persons, if they exercise the rights of free movement, to have their family members with them.
It seems like a bit of a gap, doesn't it? I mean, if it was
this case might have been apt for a reference to CJU enforcement. I think that's not available to us. Right. I think we're in agreement that that's not available to the parties here. If it is a gap, all the more, and when we can point out, we have to go back to ordinary principles, and we have to point out what are the consequences of the gap if they are construed adversely to persons in the applicant position or appellant's position, and that is for this court to decide. But I would strongly resist the suggestion that it was a deliberate omission, if that was what my lord was the suggestion. It much rather importantly, as I say, this comes back to the purpose of construction. That it should be union citizenship should be construed so that once the citizenship is acquired, one then looks at what are the effects. And the two cases we refer to of Lassal and Ziolowski, and I'll just come to those in a moment, deal with what happens in relation to, for accession states. So, and both those cases, say in Ziolowski, the Court of Justice accepted that the pre-existing residence of the appellant could count towards his right of residence under community law once Poland had acceded to the Union. So there is, this is how we put it in our skeleton argument, there is strong support for the proposition that if there were such an omission, that giving purposive effect to the construction of the directive, that that the court will look at will recognise pre-existing rights, if you like,
but there are no pre-existing rights here. You see, I can't see that the analogy even holds up, because you're dealing here with citizens in an act. Once the state has acceded to the union, then they should have the same rights as everybody else, which is fair enough. But in this situation, until Uncle gets his nationality, he isn't an EEA national and he has no treaty rights. So you can't treat him as if he had those treaty rights in the previous period when he wasn't an EEA national.
But that's precisely what happened in Mr. Ziolowski's case. He was.
We look at that.
Yeah.
Do you want to? I mean,
should we go to that case, which is at tab 13? I just wanted to go to my notes. On Ziolowski, which is
yes.
We say that. So the court. This is at tab 13. Just looking at the facts for a moment, which is that the Mr. Ziolowski was a Polish national who lived in Germany for many years and applied for an extension of their residence permit, and they were refused their rights because it was by the German state because they were told that their entitlement to a permanent right of residence under EU law couldn't be recognised effectively prior to their reliance on Poland's accession on the 1st of May 2004. And so the court, if I can just come to the paragraph 58 and onwards, which was, so if I take the start at paragraph 56, it has to be observed that at the outset of the act of accession of a new member state is based essentially on the general principle that provisions of EU law apply ab initio and in toto to that state, derogations only being allowed insofar as they expressly lay down in transitional provisions. So the support for the proposition that once the uncle becomes an EU national, that he then, that the pre-existing dependents are within his, fall within Article 3.2. Of course there isn't a case on the point, but the principles are that we say that adopting the approach of Ziolowski, that this is the court's reasoning. I'll come to paragraph 58, which is the part, just come to 57 and then 58, which is the passage with the bolding. The court held the provisions on citizenship of the Union are as applicable, of the European Union, are applicable as soon as they enter into force, and therefore must be applied to the present effects of the situation arising previously. And that's the case that we posit in our here and in our skeleton argument, as we did in support of the construction argument. And we refer to both Ziolowski and also to Lassal. I can just move to Lassal if I may.
Well, before you move to Lassal, what is, do you say, the present effect of what is the situation arising previously, whose present effects you say are being taken into account here?
The situation in this case arising previously is that the appellant is and has been for some years a dependent on her uncle, and that once he became an EU national, she was still his dependent, and that when he migrated to the UK, he was entitled to have her dependency on him treated as one which was regarded as was a dependency and is a dependency for the purpose of Article 3.2.
Isn't this addressing a different question then? I can understand that if you'd been turned down on the basis that your dependency only began when he became an EU national, or could only be counted from that point, that would be Ziolowski, wouldn't it? Ziolowski. But that's a different question. My lady was asking you about the situation arising previously. What situation arose previously with regard to the sponsor that should be regarded as having present effect?
The situation that arose previously in relation to the sponsor was that, and this is one that we say is based on the facts of this particular case, which is that the evidence before the tribunal was that he intended to move from Italy to the UK, and he moved with his family, and that he was, the appellant lives in his household now and was always his dependent.
Yes, but his intention to move to Italy from Italy to England wasn't in any way inhibited by his ability or otherwise to bring the appellant with him. It didn't act as an inhibition on his exercise of his treaty rights in any way.
But But when we
surely the situation arising, if your argument is to stand up, the situation arising previously has to be that he had financial responsibility for Sabina Begum continuously.
I mean, those are.
That's got to be it, hasn't it? I can't see how the fact that he's living in Italy and he wants to come from Italy to the UK has got anything to do with it.
Can I
Yeah,
just...
but my lady may well be right. He's got continuing financial responsibility for the
Well,
appellant.
my lady may be right. Can I,
Yes, I'm so sorry.
can I just see
Yes.
if that's right? I think it's well established in EU law that when one is dealing with inhibitions or deterrent to free exercise of rights, like freedom of movement, that one is entitled to look at hypothetical situations because one is trying to test
Yes.
not what the evidence was in a given case, but what is the kind of thing that might deter someone in principle. Now, suppose here this chap had been told when he was in Italy still that if you let her go to the UK before your citizenship has come through, that she's not going to qualify.
Yes.
He might, is this right? It's suggested that he might himself delay when he's going, wait until he's got his citizenship card, and make sure that she will qualify. So the temporal point will be if the temporal point is the fundamental obstacle, that he might delay until he gets his citizenship card. And that's not on the facts of a given case. Hypothetically,
it has an
somebody
impact
might wait.
on how he on what he does in terms of when he acquires his citizenship and what he does once he's acquired it in relation to those family members who are.
That may not be the right way of looking at it, but I just want to know what your submission is. Is that one possible way of looking at it? Because in EU law, as I understand it, I may be wrong, one is entitled to look at hypotheticals.
I mean, in any construction case, as my lord will just indicated, we can't just be confined to the facts of this case. We have to look at the construction in a broader context, and that then necessarily requires a degree of hypothetical considerations. But in circumstances where we have this lacuna in relation to, or apparent lacuna, in relation to those who acquire citizenship and what that means for those pre-existing relationships, then certainly one hypothesis is that he would have he would have acted differently in relation to the appellants moving to the UK. He could have acted differently in relation to acquiring the date at which he acquired Italian citizenship and migrating to the UK. He would have, we would submit, if he had known that there was a temporal limitation, he would have would have made sure that she would have qualified on the Secretary of State's analysis, and so that would have impacted on how.
I'm not sure though that leads to him being deterred in any way from exercising his free movement rights, because on my hypothesis, by definition, he's not yet an Italian national. So merely to delay becoming an Italian national isn't the relevant decision. What you'd have to show is that having acquired Italian nationality, he would in some way be deterred from moving to the UK to work. I'm not at the moment, like my lady, I'm not seeing any connection between that and the temporal issue we're dealing with.
Yes, the deterrent effect in relation to his own actions would appear to be in relation to, if we accept that once he acquires Italian nationality, the appellant, as his dependent, is entitled to come to the UK if she were still in Bangladesh, which is the case, then the way in which it would be an effect would be for him to not to have advised her to come to the UK as soon as she could in order to study and then live with him, but to advise her to delay that until he had moved.
But that's nothing to do with his exercise of his
That's
rights.
an
You would have to show that it would be a disincentive to him moving from Italy to the UK, that his niece would not get rights of residence here in these circumstances without waiting until he'd moved. That's what you've got to show, that it would actually act as an inhibitor to his exercising his rights as an Italian national to move freely around the UK, into the UK.
If one, it doesn't necessarily arise on the facts of this case, but if the only way in which they could live together would be in Bangladesh, then he would obviously have to return to Bangladesh if she were denied a
But
residence.
they've never lived together until she came to the UK, so that doesn't work either.
But but on the facts of the case, they did live together. They have lived together in the UK now for some years, and certainly at the time of the application and the time of the decision. Perhaps the better deterrent analysis for deterrent effect is what is the impact now, which is back to the point that we made, I think, earlier on, which is that there is an impact now on the sponsor, on the EU national, of having his dependent be required to return to Bangladesh to
And
get.
how does that affect
I'm
his
sorry,
treatment?
it sounds
Yes.
as if, as it were, this is not really about deterrence. It's just about that there are burdens and disadvantages from applying the rules in the way which are.
Yes, I mean.
Sorry, you were multitasking there.
I'm so sorry. Yes, a possible one.
You
of
follow the point that I make.
Yes,
I mean,
indeed.
it's just simply. I mean, all of these points lead to the one to ask the question. Well, why don't we just do it the right way?
The way the court. Well, I'll come back to that point in terms of the right way. One of the both.
Or the way that's plainly intended on the face of the regulations, which you're saying should be read differently to account for the situation that's now arisen.
Yes, I'll come back to that. In Lassal, the court was concerned to interpret the regulation and the directive on the possibility of an adverse effect. Not even didn't have to show that there was, but the possibility. And this is back.
Yes, but I mean, falling the wrong side of a rule is not an adverse effect.
Yes,
It
I
may
mean,
be
the
tough,
question is
but
whether
it's
it's
There
not,
has
it's
to
not
be
a deterrent.
there has to be a real deterrent effect, even if it's a hypothetical one. In Adelazilu, the deterrent effect was said to be that he would not move, or she, I think, sorry, it was a lady, that the Dutch national would not make her plans to come to the UK at all if the relatives who were here illicitly were sent back to wherever it was, Nigeria, I think, because she intended to come and make her home here with them.
Yes.
And so it was said that it would potentially act as a deterrent, they having already established themselves here. If they weren't to get the rights of residence, it would inhibit her from exercising her treaty rights. But how does that translate to a situation where you say, well, at the point of entry, there's got to be a dependence on an EEA national. Let's assume that's for a moment that's the correct way of reading it.
Point of application.
At the point of no, not at the point of
on the
application.
person.
Let's take the literal construction.
Yes.
Your argument is that if you construe it literally, it has a chilling effect. It has a deterrent effect. I'm just trying to explore why it has a deterrent effect. At the point of entry, if you can show that you are dependent on the EA national, then you can come in, and the EA national is no way inhibited from exercising his treaty rights. If he acquires Italian nationality at a later stage and wants to move to the UK, he can move to the UK, and then if there's continuing dependency, he can bring the person in from the third country. And again, at the stage at which they enter the UK, they will acquire rights on the back of his. So again, no deterrent effect. Where's the deterrent effect? Hypothetical.
In a particular case, and not necessarily the facts of this case, for somebody who is a dependent or a member of a household, if they were not if that third country national were not given a residence card, then for those reasons that they'd only now acquired nationality, then there is certainly a hypothetical scenario where that person would have to.
Is this? I don't know. I don't know if this is accurate, but are you saying that, let's say today he gets a job offer in the Netherlands?
Yes.
And so he's thinking of moving to Amsterdam, but he's told that because the extended family member doesn't have any rights under EU law as part of his family, that if he can't take her with him, that he might be deterred from taking up that job offer. Is that what's relevant, or is that just the wrong way of looking at it?
I mean, on the facts of this, on a case of acquisition with pre-existing dependency, that wouldn't arise because he'd be entitled to move to the Netherlands with his. I mean, that's another example.
This would be the third country, as it were.
Yes, I mean that's on the Netherlands example.
I probably made myself completely unclear, I'm afraid.
Oh, I see.
I'm dealing with hypotheticals.
Yes, but on an example of somebody wanting, if we were to move, if the sponsor or the worker were thinking, I can't now move to a third country because that person is my relative is not going to be treated as a dependent, then that is a potential deterrent effect. Although
can I start again? So it's my fault. What she wants, in practical terms, is the residence card.
Yes.
That's what this case is all about.
Yes.
Right? This may or may not be right, which is why I'm asking you the question.
Yes.
Does the fact that she doesn't have a residence card to live in the UK in any way mean that she could not join him if he takes up an offer of a job in the Netherlands?
No.
Okay, no. Right. Well, in that case, that's a red herring, and forget about it.
Yes, in this sort of scenario, in fact, that was one of the reasons why.
In that case, I'm afraid I simply do not understand your submission that there is currently any deterrent effect to his exercising his free movement rights.
So, my lord, just in response to the Netherlands point, or any third country, further EU state, we say that demonstrates why, given that she would be admitted to the Netherlands as his dependent because she's the dependent of an EEA national and a member of his household now, that's why we say that, and then if they wanted to, if the UK hadn't left the EU, they'd have been entitled to come back here until the exit agreement. But that demonstrates why denying her a residence card here now, for the reasons given, just isn't going back to the purposive construction case. It may not necessarily be, it doesn't really address the deterrent effect point, I accept that. But it goes back to why the purposive...
Yes, so you've chanced upon another example.
Yes.
The first being that she could go back to Bangladesh.
She could go back to Bangladesh, she could move to another country. Any other dependent from Bangladesh could come here continuously, but not now, because the sponsor was acquired EU nationality. But... I think the better focus for this case, the analysis, is about the purposive construction point that we've already dealt with. What are the if there are any potential adverse effects? What are, sorry, I'll come back to Mr. Kelly's point in a moment. What are the adverse effects? And back to my Lord Justice Peter Jackson's point in relation to, is there a right, should the directive and the regulations be construed to suggest that there's a right way to make this application, i.e. go back to Bangladesh and make it, because that is not how ordinarily the EU law would be interpreted in relation to how to facilitate, that's the word in Article 3.2, facilitate entry and residence of dependents, and that the impact of that construction is an effective requirement to leave the country and come back. That, in my submission, is why the strongest support for the proposition that it can't be construed in that restrictive way, and that there is a remedy to deal with persons who don't qualify or for whom the Secretary of State is concerned about in relation to their conduct, which we looked at under Regulation 18, Regulation 18, and which is contained within the directive itself, Article 3.2, after an extensive examination of the facts. And my learned friend's case, as I understand it, as I think it's absolutely clear, that the Secretary of State, she says, hasn't been invited to do that and hasn't done so. Secretary of State hasn't done so because she's taken the view that she's not another family member, and there's a certain circularity to that argument, because if we're correct on the other family member, but my Lord was concern was one that the Secretary of State shared, which is you haven't done it in the right way, she's entitled under national legislation, if she wants to say, no, I'm going to resist that. I'm going to resist the exercise, I'm going to deny the exercise of discretion, I'm not going to admit to you. So there's a perfectly proper and, in my submission, obvious sort of solution to the objections that the Secretary of State raises. And the Secretary of State's been very careful to say, no, this is all about definitions, so that then, but really, the reason why she's made it all about definitions is to avoid having to face up to that argument, which is if you are another family member at the date of the application, and you can show the prior dependency and dependency now, then we say that brings us into the other family member definition, and that the way, if there was going to be a refusal, it would be based on the basis that you haven't done things the right way. It would be remedied in that particular way.
It might, forgive me, it might be said circularity with respect is in your argument that
Yes.
that if it was that you, because you don't fall within the definition of extended family member, you say that somehow the language of the regulation and the directive should be construed in a different way from its ordinary meaning, because that would give effect to the purpose of achieving what you say sensibly should be achieved. But actually, as my Lord points out, there was a very simple solution to all of this conundrum, which is that she could and should have gone to Bangladesh and applied. And if she hasn't gone about it the right way, why should the legislation be construed differently from its ordinary meaning?
Well, my Lord, I'm just going to take the court back to Rahman and to SM, which deal in.
We don't need to go, do we, to Lassal, because that's you've
Oh,
caught
right,
up
we've
with
dealt
that
with
in
yes.
Ziolowski. All right. So
So
Rahman next.
If we go to Rahman, that's at tab 12. Just bear with me. So that just reminding the court of the facts there at 233 top right, which was they were all the applicants were Bangladeshi nationals, a brother and half brother and nephew of the Bangladeshi national who married an Irish national who was working in the UK, and they were seeking to rely on the requirements for the host member state to facilitate entry and residence. Their applications for residence cards, this is by just above G, were refused on the grounds that they hadn't proved that they'd resided with their Bangladeshi national Irish wife in the same state before she came to the UK, or that they continued to be dependent on her, or were members of her household. So they're not. They're not in the same situation as that which we contend for here.
Well, that was the basis on which it was refused. That decision was reversed by the first-tier tribunal, and it was then referred to the CJEU on various points of law. The most important one being the question of whether they had to be resident in the same country as the sponsor, which was the third issue, I think, that was referred to the CJEU.
Right. The third and fourth questions. So, if I can just take the court to the first of all to the Advocate General's opinion, and then to the judgment. So the Advocate General's opinion, the relevant part in relation to these questions, is particularly at 86. The third question the referring court essentially wishes to establish whether or not the class of other family members referred to is limited to those who've resided in the same state as the Union national and his or her spouse before the Union national came to the host member state. And then the fourth question is essentially whether the dependency on the EU citizen or his or her spouse required in Article 3.2 must have existed shortly before the citizen moved to the host member state. And at paragraph 90, he says that, first of all, he notes at 89 it's dependents or members of the household. And he says, I share the Commission's view that a distinction should be drawn between the situation of dependents and the situation of members of the household. But what would seem to be self-evident is that the family members who declare themselves to be members of the household of the citizen must prove that they reside with the Union citizen and necessarily in the same state. I take the view conversely that the dependent family members cannot be excluded from the scope of the article on the grounds that they hadn't resided in the same state as the Union citizen whom they wish to accompany. So that's the answer to the question that was posed there. They then, at paragraph 91, it says it should be noted the family members for whom the member states are required to facilitate entry and residence are defined under Article 3.2, and I accepted that for the purposes of the questions in Rahman, they were concerned with those from the country from which they have come, because the facts of this case didn't support any post-migration dependency. That's how we distinguish Rahman on the facts. Rahman was considering the question of dependency pre-migration because there was no post-migration dependency claimed. That's an important...
Because they didn't come in. There could be no post-migration dependency because they didn't actually get into the country.
Yes, but the court didn't examine the question. They weren't examining the same question as we're concerned with here.
No.
That's really the point that I make. And then the bottom.
Forgive me for interrupting you, but before we leave the Advocate General at paragraph 91, you're right. Of course, the issue of law which arises in the present appeal is not the issue of law they were there addressing. Yeah. But nevertheless, both the Advocate General and the court in due course, as we shall see, do appear to place some weight on the clause in the country from which they have come. They don't say that that's just irrelevant.
No, and it's not irrelevant on the facts of Rahman because it was the only context in which the issue of dependency was being and could be considered. But we submit that our case requires an examination of the dependency that existed in Bangladesh and the dependency that continued to...
Just so I'm pointing in the right direction, are you seeking to rely on Rahman or to distinguish it, or do you want bits but not other bits?
We want to say that Rahman allows for a purposive construction.
Well, I don't think anybody's anybody's saying there should be a mechanical construction of any of this. So beyond that, is there anything that you rely on in Rahman?
But in Rahman, we're distinguishing the way in which the Secretary of State relies on Rahman, and we're distinguishing Rahman by saying it was effectively addressing a different question.
Right. So in that case, if it's not a plank of your case, is it something that we need to spend a long time on, or can you reply on it?
I could deal with it in reply. I just wanted to take the court to two passages in the.
Yes, because I only want to see the bits that you rely on.
Yes.
Miss Smythe will tell us the bits that she relies on.
Yes. The particular bit is at perhaps 35 and 37 of the Advocate General, where he.
35. We're going back.
So yes, apologies.
Okay.
35 and 37 of the Advocate General, where he says that.
Teleological interpretation, right?
Yes,
Purposive.
So
Meta.
that's it. And then just for
Yes.
perhaps for the court's notes, and 37, the objective being to promote family unity. So
Well,
that's
the first objective is to promote free movement of union citizens.
yes, and then he adds in, according to the recital in, 37. Did I say 36? Apologies.
35 to 37.
Yes, according to the recital in 6, the second objective is to promote family unity. So that's the proposition there.
Right.
And in relation to SM, that's at tab 11. And again, the court will be just familiar with this case being a question. Again, the other CJU question about construction of Article 32, and then in a circumstance where the Supreme Court in this case had referred the question, or already accepted that the what was called the kefala adopted child fell within the definition of another family member because she was a dependent and also a member of the household of the EEA National. But just the passage in relation to SM that I wanted to take the court to was at paragraph 60. Again, that the court must take...
Advocate General or court?
Oh, so sorry. I think I'm still in the...
60 of
yes,
the Advocate
60
General,
in the,
more purposive.
Construction.
Yes, it's 60 in the court judgment. Apologies. But
Well, I think these are just general points about purposive construction.
Yes.
And once the court says it once, it says it again and again and again. So
Yes.
We have
So
it.
those are the two particular authorities in relation to construction. So, but neither of those cases there's no case that that Secretary of State in my submission can identify that supports the approach that the appellant in her circumstances, albeit that she could qualify now, should be required to leave the country. That is the direct consequence of the approach of the Secretary of State, and there isn't any other meaningful or available remedy for the appellant. If I just may just turn my back for a moment. My lords and my lady, sorry, just note the final point, just for my court's note, was Mr. O'Kelly was pressing upon me, was to remind the court of the 4 principles of interpretation, which the court, in the Attorney General's opinion, in Rahman at 33 to 39. I gave the court 2 paragraph references.
You gave 35 to 37.
Yes,
You'd like to
so-
extend it to 39.
yes.
All right. Well,
33 to 39. Thank you.
thank you.
And so the final point, so in conclusion, that's what we say, is that to interpret this provision restrictively would have a broader impact on all persons who require EU citizenship, and the Secretary of State's argument, which would necessarily follow, which was that rights would then only then be forward-looking. And we say,
But the fact of the matter is that either interpretation will have a broad impact on a number of people.
yes,
it doesn't push one way or the other, does it?
Yes, we contend for, as we say in our skeleton argument, not a restrictive.
Yes.
No restrictive construction. If I just make it there with me one minute. Yes, I think I've covered all the points I wanted to cover.
Yes, thank you very much indeed. Yes, Miss Smith.
Thank you, my lord.
Will you start by satisfying my curiosity as to how we pronounce your name?
It's Smythe.
It's Smythe. Thank you.
Thank you. I may be able to finish by lunch.
No, you should just take it at your own pace. We have plenty of time, and we've urged Miss Nike to deal with certain matters in reply if they seem appropriate to her. So.
Indeed, I'm grateful. Can I take matters in this order? First, to make my headline submissions. Second, just to make a couple of basic points on the extended family member right. And then third, make good my headline submission, which is what I've described in my skeleton argument as the basic requirement in EU law of dependency on an EU citizen in the state of origin. And we say that that submission is effectively dispositive of this appeal. And then finally, I will just, as a mop-up, deal with various arguments that have been advanced to the contrary. So to begin then with my headline submission, it's become clear, I would submit this morning, that the Secretary of State is clearly right on a textual approach. And the right description in my submission is that it's a textual approach rather than a literal approach. And that is an accepted canon of construction in EU law. Indeed, if the text is clear, the court doesn't need to go to a purposive construction. But the second point is this: to the extent that it is relevant to undertake a purposive construction, then the answer is also the same. Because the position here is straightforward in that EU law imposes one condition. It's set out in the provision, Article 3.2. And that condition, that imposes a condition which relates to the situation in the country from which the applicant comes. So, as my Lady Justice Andrews has observed in the course of argument, anything else is for domestic law. All that EU law is concerned with, the only condition it imposes relates to the situation shortly before the person moves, what the position is in their country of origin. Now, that being so, and in my submission it's clearly so, it simply makes no sense whatsoever to say that the one condition EU law imposes can be satisfied by a person who at that time has no connection whatsoever with EU law. So just to unpack that point, what Article 3.2 does is it looks at the situation in the country from which the applicant comes. That's all it's concerned with. And what it's doing is at that point saying, is there dependency on a union citizen? But on the appellant's construction, one doesn't require a union citizen at all at that point, and that, in my submission, is clearly wrong, because there's no connection at all with EU law if there's no EU citizen who has a right to free movement. Now, it's right in my submission that there have been various cases domestically about the continues to be dependent requirement, but that's something which domestic law has imposed. Other countries might not. So if this construction is right, it must be right across the EU. it means that a person can come, the applicant can come to a member state, dependent at that point on a third country national. There can then be, say, a 3-year gap before the person on whom they're dependent becomes an EU national, and no further dependency, because that's a matter for domestic law, and nonetheless, on the appellant's case, the EU requirement is satisfied. We submit that that's simply wrong, and one doesn't need to go any further than that. One can't get into purpose if there's simply no connection with EU law, because there's nobody with any EU law rights.
Are you going to take us to the text of the directive?
I am, my lord. Yes,
Right, I'll save my question for then.
Yes, I am, although I'm happy to answer it now.
Well, can I just say what might be said? I'm not saying it's right, but what might be said against you is simply that when the directive refers to the union citizen, it is simply identifying the person about whom we are talking, and is not a temporal limitation. So it could have said, on the facts of this case, the uncle.
Yes, but it doesn't. It's and I'll come on to the language in detail, but in my submission, the language doesn't support that construction.
Could I put it in this? Could I frame it in this way, just to see whether I'm getting the point? In other words, that an EU citizen is using as an identifier and not as a status.
Yes, but that can't be right in my submission. So when Article 3.2 is concerned, because it is looking at a point in time at which the person moves. And since the person who moves is a third country national, there has to be something in the provision which links to EU law. So it can't simply be an identifier, because the need for there to be an EU citizen with a right of free movement is the very thing which gives rise to the right in the first place. Because what has been made clear in case after case is that family member rights are not autonomous rights. They are contingent on the exercise of free movement by an EU citizen. So in my submission, it can't simply be an identifier, it has to be more, because without the substance, in other words, an EU citizen with free movement rights, there's no connection with EU law at all, and there's nothing on which the family member's derivative right can bite or stem from.
The family member is not the possessor of the right, but the beneficiary of the right as it's described.
Exactly, and it's said in case after case, and I can probably find it's said so often that it's probably in one of the cases in the bundle, but effectively the court says over and over again, family members are not autonomous rights of the family member, they are derived from the EU citizen's rights. So in my submission, without an EU citizen with rights in substance from whom a right can arise, then Article 3.2, which focuses on the point at which the country from which the person comes, simply can't just be an identifier. It's got to be doing more.
Well, you say that, and you may be right. But like with so many legal questions, often if one assumes the answer, one undoubtedly gets there. But you see, it might be said, I'm not saying this is right, but it might be said that the union citizen is simply being used as an identifier, that at the point when she applies for her residence card, the uncle is a union citizen. So it might be said that you're in this territory. What that then I think means is that you submit that the present tense are has to do a lot of work.
Yes, but there are a couple of other provisions in the directive I will take the court to. What I would say on that point about art, what about the point of application? Whenever the application is made, the point is that the EU law requirement needs to be satisfied. And in my submission, if at the point that the person moved, there was simply no connection with EU law because there was no EU citizen to give rise to a right, then that condition is not satisfied.
Yes.
That's the point.
Yes.
So it isn't so much that the time at which the application is made, it's the underlying condition which the application needs to satisfy in my submission, and that is a condition that at the point the person moves, they are dependent on someone who is presently an EU citizen.
Because the person who makes the application has to satisfy the definition at that point in time of being an extended family member.
Yes, and because exactly that, the definition refers to and hinges on the situation in the country from which they've come. I'll come to the definition now, because I submit it's clear that the way to construe an EU instrument is textual, contextual and purposive. And if one looks not only at the text but also the context and other provisions and takes into account my purposive point that I've just made, it's abundantly clear in my submission what the answer is. The only point I would make as a headline point is this, that these arguments are, in my submission, very similar to the arguments that failed in this court in OVO, which is to argue for a purposive construction which ignores the language of the directive. OVO is a case where they had the EU national, the relationship with an EU national before they moved, but they didn't have the dependency. Here we have the dependency but no EU national, but in effect both of them fail half of the test in my submission, and the court, my lord.
Well, I follow your argument, obviously, but in the text of 3.2a, if there had been included the words were and, so who in the country from which they have come were and are, then if that's what the text says, I think you would accept with you the appellant wins. But your fundamental submission is the text could have said that, and it didn't say that.
Well, yes, one, I'm not sure I would accept that, because I could still submit, well, you weren't dependent on an EU citizen at that point.
Yes, I see, yes. No, I understand.
And the second point I would make is that would fundamentally alter the right, because the ongoing, the need for dependency is for domestic law. So we come back to the point that the only thing that EU law cares about is what is happening in the country from which they've come. That's the bit, that's where it imposes a requirement. And if there's no EU citizen, then there's no reason to impose a requirement in EU law, because there's no connection with EU law. So in terms of I'll come on to the second bit of my submissions now, which is the language, the second part of my submission is just briefly on extended family member rights, if I may. Just to be clear, yes, there are two stages to establishing an extended family member right. One, do you get through the gateway, and two, do you win at the discretion stage? And I've dealt with that in my skeleton argument. I won't repeat it again. The one point I would make in response to some of the points that have been made in supplementary skeleton arguments is that this is not the issue of a residence card for an extended family member is not declaratory. It is effectively constitutive of the right, and the authority for that, it's dealt with in my skeleton at paragraphs 19 and 20, that there have been several cases of this court on the point, but the most recent is a Bangby at tab 5. So I can take the court to that if it would be helpful, but the point hasn't been made.
I agree. I agree with that point.
I'm very grateful. So where the supplementary skeleton says if she wins now, it's declaratory, it's not. All it gives her is a right from the point that the residence card is issued. So for the court's note in the Bangby, the key passage is at 35 to 38, and that's at tab 5. So, having cleared that up, the third part of my submissions is my main submission, the basic requirement in EU law of dependency on an EU citizen. Could I start with the language of the directive? So, Article 2 begins on page 27. Article 2 defines what are often referred to as direct family members who have an automatic right of residence. And it's important to note in my submission, this is a contextual point, that Article 2.2c makes provision in relation to direct descendants who are under the age of 21 or are dependents, and those of the spouse or partner. But notice that the words "in the country from which they have come" only appear in Article 3(2)(a). So the legislature, in my submission, clearly felt that they were important. They're also absent, those words, from any of the other limbs of Article 3(2). So that, in my submission, is the starting point, and then my point is a simple one, and I've made it in response to my Lord Justice Singh, that this is clear language. It says, who, in the country from which they have come, are dependents of a union citizen having the primary right of residence. So not only a union citizen, but a union citizen who has the primary right of residence, because that, in my submission, is the link to EU law. And it doesn't say were, it says are. And unless in my submission one is to simply ignore the words "in the country from which they have come", then one has to look at whether the requirement is satisfied in the country from which the person comes just before they move.
I think Ms. Naik, when asked about this, accepted that the words "in the country from which they have come" must be given some effect. So she doesn't suggest that, as it were, one mentally deletes that clause. But what she says is that that will be satisfied in a case such as the present, because the applicant was dependent in the country from which she came. But what Ms. Naik submits is that you have to insert the words "were" and before the word "are." And you say that that's impermissible, that's not interpretation, that's legislation.
Indeed, and I would add that it's a very strange outcome indeed, because if one recasts this legislation, bearing in mind that we know that EU law doesn't care about what happens after the person arrives, and when I say that I'm talking about Rahman question 6, that this could simply say any other family members, irrespective of their nationality, not falling under the definition in point 2 of Article 2, who in the country from which they have come are dependent on a third country national. Because this provision, we know, it's crystal clear from Rahman, this provision is only about the position immediately before and at the point the person moves. So one can't construe an EU provision by reference to what different member states may or may not have done as a matter of domestic law. One has to look at the EU condition as it applies. And if Miss Naik is right, then all that it needs say is somebody who is dependent on a third country national. And in my submission, it doesn't say that. There's no reason for it to say that, because it would be an EU law provision saying you need to do this, you need to be satisfying this requirement before you come, but doing so in a way that has no connection at all with EU law. So that really is to wrap up context, text and purposive, but it isn't even so much purposive in my submission as absolutely fundamental. Because if there's no EU citizen with a right of residence, there's no right at all and nothing for EU law to provide.
Can I ask you about this scenario? In opening the appeal, Ms. Naik suggested, and she may be right, and I'd like to know what your answer is to this, that on your interpretation, all that the applicant would have had to do is fly back to Bangladesh and apply from there. And so if that premise is correct, one is left wondering, what on earth is the point of all of this? If it can be circumvented that easily, why put people to that trouble if that's all that they need to do?
Well, can I answer that with 3 points? The first is this, that there is a condition which applies, which imposes a particular requirement. And as I understand it, Ms. Naik accepts, at least I'm right on the text, but she says, well, that's silly because somebody will have to go back to Bangladesh. Well, the first point is that is the condition. The second point is that if Ms. Naik is right, it would apply to the OBO situation, because what the court could have said in OBO is, well, you're clearly dependent now, you're here, so you need that money, but you need to go back to your country of origin and be dependent there. And since you could do that, we might as well just say that you qualify. But of course, the court didn't say that. It said you can't use a purposive type construction to remove clear conditions in the directive. The third point is this, that it will often be the case that a person doesn't satisfy a requirement, and EU law is absolutely clear that if what you do is arrange your affairs so as to comply with the requirement, that isn't an abuse of rights. So it isn't uncommon, indeed, in the broader immigration context, for people to arrange their affairs so that they comply. But that doesn't mean that one can say, well, let's ignore the condition then, but one has to apply the condition.
So it wouldn't be open to your client to, if this applicant went to Bangladesh and applied, to say, well, no, we're going to refuse you because this is just a sneaky way around
yes,
the problem that you had before.
Yes, and that was going to be my final point on this, because in fact the court addresses it in Rahman on question 5, because Rahman question 5, and I'll take the court to that in a moment if it would help. Rahman question 5.
So is this your mop-up?
No, this
is the fourth point. This is the fourth point in answer to why not fly back to Bangladesh.
It is. It's still part of my response.
All right. I thought you said you had 3 points. That's what threw me.
Yeah.
Right.
So this is part of my third point in terms
right.
of, yes, people can do that to arrange their affairs, but if they do it so that it's a device, for example, then it's open to the member state to impose something in its domestic law, provided that it isn't consistent with what the court says under question 5 of Rahman, because what Rahman effectively does is ask 2 separate questions. First, it says, well, can the member state set requirements about dependency in the member state of origin? And I'll show the court that in a moment. That's question 5. And at question 6, it says, can the member state impose ongoing requirements as to dependency? So if, for example, somebody, in whatever way, and this is a question of principle, but if somebody didn't satisfy the EU law condition and then did something, well, I'll just go and stay in Bangladesh for a day or so, then one might say, well, you're not actually complying with the condition, which is for there to be substantial dependency in the country of origin. See Rahman, paragraphs 33 to 35, and I'll take the court to that in a moment. But again, that would be a matter to be played out in domestic law if somebody does do that. But the primary point is, and it's a point, it was a point put to my own friend in argument, no, but that's the condition, you need to comply with it. You can't say, well, I could have complied with it by doing this and I didn't. Either the condition's satisfied or it isn't. So that's my answer to that point.
Thank you. Before we leave the text of the directive, can I just really try and draw some threads together? I think in answer to my Lord's question about whether there's simply an identifier or a status, you submit there is very definitely a status here, because it's not just the phrase the union citizen, it's the union citizen having the primary right of residence.
Yes, and that has to be so for there to be any kind of potential right for a family member, because it's parasitic on the exercise of a right of residence by a union citizen, and there is, I can find as I say, there may be one in the bundle, but I can find a case to that effect, because there are a number of cases in which the court has said the family member right is parasitic on the exercise of the right of residence by a union citizen. So one has to read the whole thing, and in my submission, if one does that, it's quite clear what's being said. In the country from which they have come are dependents of a union citizen having the primary right of residence. And indeed, it's not in my submission a surprise that EU law would do that, for the reason I've set out in my skeleton argument and submitted as part of my headline point. Why set a condition that at the point it needs to be fulfilled doesn't have any connection with EU law? So that's in my submission. So textually, contextually and purposively, indeed not just purposively but fundamental principles of EU law, means that is the right construction. But so far as the text is concerned, can I also invite the court to look at Article 8.5e? This is headed Article 8. It's paragraph 95 of the journal, pagination 35. of the bundle pagination. So it's headed administrative formalities for union citizens, but could I then invite the court to look at 85E, which is on page 37 and 97. So what this is doing, it says 8.5, for a registration certificate to be issued to family members of union citizens who are themselves union citizens, we'll see this is mirrored for third country nationals as well. Member states may require the following documents to be presented, and then 8.5e says, in cases falling under Article 3.2a, a document issued by the relevant authority in the country of origin or country from which they are arriving, certifying that they are dependents or members of the household of the union citizen. Well, at the point that she moved, that the authorities couldn't have done that, because what they would have had to have done is produced a document saying, yes, I can certify that she's a dependent, but it's a dependent of a national of Bangladesh. So again, 8.5e, and this is mirrored in 10.5e for for non-EEA nationals, is again,
forgive me, this, on any view, is this right, must be happening at the point in time when the application for a residence card is made.
Well, the difficulty is that the legislation is premised on the person satisfying the condition at the point they move. Domestically, we accept that an application could be made later, provided there is an ongoing dependency. But so far as the legislature is concerned, what it's concerned about is what's happening in the country from which the person is arriving, and it does envisage an application.
Well, that's your submission, and I understand it, about the meaning of 3.2a. I'm just querying whether we get any further assistance from 8.5e.
It's simply my submission making clear that the legislature is concerned about what is happening in the country of origin, and it's, in my submission, it's Article 3.2a that does the heavy lifting,
yes. But
it's right for the court to see Article 8.5e and Article 10.2e. So that's the text, and I say it's clear. Could I then invite the court to look at Rahman? And my headline submission in Rahman is that the court isn't just talking about the facts of Rahman, it's talking about Article 3.2a in general, because this is a decision of the Grand Chamber. It's the first time that the court's been asked to interpret what is a new provision in the directive. And if one looks at the court's language, it's quite clear in my submission that what it's saying isn't directed to the particular fact, but rather is directed to the whole point of this requirement. So we've sidelined the basic background. I don't need to take the court to that, but the key bit from my perspective is questions 3 and 4, which begins at paragraph 27 of the judgment, 279 of the report, or 263 of the bundle. So there are two questions that are being asked here. One, is it necessary to have resided in the same state as the EU citizen? And second, is it necessary to have been a dependent of the EU citizen shortly before the EU citizen moves? So it is a point of principle which requires the court to engage with what Article 3.2a is actually doing.
Which paragraph are you in, sorry?
Paragraph 27.
Thank you.
So it's questions 3 and 4. And then what the court says at paragraph 31 at the top of 280 of the report is, it's clear on reading the provisions that the country refers to is, in the case of a national of a third state who declares that he is a dependent, the state in which he was resident. So the applicant, on the date when he applied to accompany or join the union citizen. So unsurprisingly, it's the language language that it's using is premised on the application being made at that time. But the reason that it uses that language, because that's the point at which the requirement bites. So that is saying what we're looking at when it says in the country from which he comes, it's talking about the third country national's country of origin, and then the court goes on to deal with, well, when does the person have to be in a situation of dependence? And this is paragraphs 32 to 34. And what the court says, and in my submission this is clearly a general point, in paragraph 32, the objective of Article 3.2 is to maintain the unity of the family in a broader sense by facilitating entry and residence for persons who are not included in the definition of family member, but who nevertheless maintain close and stable family ties with a union citizen on account of specific factual circumstances. Now, again, I won't repeat my submission, but it's obvious why there should be a need for close and stable ties with a union citizen. And then the court is quite clear in paragraph 33, such ties may exist without the family member of the union citizen having resided in the same state as that citizen, or having been a dependent shortly before or at the time when the latter settled. So that's the EU citizen. So in a sense, what the court's saying is, well, we don't really care about the position when the EU citizen moves. We care about the position when the third country national moves. And there the court says the situation of dependence must exist in the country from which the family member concerned comes at the time when he applies to join the union citizen on whom he is dependent. Now again, the court is using the language of application, but that of course is the usual situation, that a person will apply at the point that they want to come to the country. The fact that under domestic law we permit a later application to be made doesn't change the nature of the condition, because that in my submission is what the CJU is referring to.
Isn't that, I mean, that would have been a perfectly sustainable submission, but for the decision in Al-Adazili, because it's not just pure domestic. Al-Adazili says that as a matter of EU law, it doesn't matter which of the two turns up first. And therefore you can't read that particular passage in Rahman completely literally. I think Lord Justice Beatson says that you've got to look at it in the context of the type of situation which is the norm, which is where the EU citizen comes here first and then somebody's applying from outside the jurisdiction to join them. But where you've got a situation where it's the other way round and the dependent turns up first and then the EU citizen comes to join them, you can't say that you focus entirely at the time of the date of the application for entry, because that doesn't arise.
No, and can I make 3 points in response to that? The first in my submission is answered by Rahman, because what the applicants in Al-Adazili had and this applicant doesn't is that they did have dependency in the country from which they had come.
Yeah.
The second point on Al-Adazili, and it's a point that your ladyship made in the course of argument, is that there was a very specific argument which was being advanced by the Secretary of State in this case, and it's captured at paragraph 38 of the judgment. What the Secretary of State was arguing is that the Secretary of State didn't take a point on joining, but the Secretary of State said, well, the applicants can't fill the requirement as to dependence in the country from which they came at the time of application because they came first.
Yes.
But the point here is different. The point here is, but you simply don't satisfy the substantive requirement. And the third point I would make on Al-Adazili is, in fact, it supports my position, because what Al-Adazili is addressing, and this is at paragraph 47 and 48, is that at paragraph 47 the court was addressing that very specific submission of the Secretary of State, which was using the language to cut somebody out, but it didn't go to the substantive condition. But what the court then goes on to do is say it establishes a need for a situation of dependence in the country from which the applicant comes, and a situation of dependence at the date of the application. Well, that has to be read in the light of Rahman question 6, because as this court has found, yes,
and over.
Yes,
all right.
and Chowdhury, but
Ms. Smythe, I think at the moment, I think there's some more work to be done on this area, and probably it's better that
sorry.
Not at all. But it's just these are important points, and I don't want them to be either rushed or not understood. So let's start again at 2:05.
Thank you, Will.